If you think the Supreme Court just gave gun rights a huge win, stop right there. An 8:1 ruling just made it easier in some cases for the government to take firearms away from people and send them to prison if they don't listen. We're talking about real consequences here, like losing your gun rights, facing felony charges, and in some cases years behind bars. And if you miss what changed, you could be trusting the wrong advice at exactly the wrong time. Before we go further, quick question for you. Are you subscribed? Know then you're missing updates that could save you from bad legal decisions and expensive mistakes. Hit that button now because what I'm about to share affects gun owners, families, people under protective orders, and anyone trying to understand their rights. Click subscribe right now. Here's what most people don't know. This so-called bombshell is about a Supreme Court case called United States versus Rahim. The court ruled 8-1 that a federal law can stop certain people under domestic violence restraining orders from having guns. In plain English, the justices said, the Second Amendment does not always protect someone who a court has found to be a real threat to another person's safety. Now, listen, this matters because the Supreme Court had already changed gun law in a huge way with an earlier case called Bruin. That case told lower courts to look at history, meaning old American gun laws, when deciding if a modern gun rule is legal. A lot of judges took that rule and ran with it. They started asking, did this exact law exist in 1791? And that's where things got wild. Here's what just happened after that. A federal appeals court had thrown out the law used against Rahim. That lower court basically said the government had not shown a close enough match in old history. So people on both sides of the gun debate thought this new Supreme Court case would either blow Bruin wide open or lock it in even harder. First thing you need to understand is who Rahim was and why the facts mattered so much. This was not a calm, technical paperwork fight. According to the record, Rahim was under a restraining order after a violent incident involving his girlfriend, and police later connected him to several shootings. That doesn't decide every legal question by itself, but it absolutely shaped how the court looked at danger. Here's the crazy part. The court did not say if someone is bad, the government can do whatever it wants. It said something narrower but still powerful. The majority said that when a court finds a person poses a credible threat, meaning a real and believable danger, that person can generally be disarmed for a period of time without breaking the Second Amendment. That is the turn nobody should ignore. Let me tell you why this matters. Before this ruling, some courts were reading Bruin almost like a photocopy test. If a modern law was not nearly identical to some old law from the founding era, they were ready to strike it down. Chief Justice Roberts said that was too rigid. In other words, the Constitution is not frozen like an old photograph. Here's what most people don't know. The Supreme Court said modern gun laws do not need a historical twin. That means the government does not have to find a perfect old law that looks exactly the same. Instead, courts should ask whether the new law is relevantly similar to older laws and why it exists and how it works. That sounds technical, but it changes everything about how these cases will be argued. Think of it like this. If people in the founding era used one kind of legal tool to stop dangerous threats, the government today may be able to use a different tool aimed at the same problem. It's like if people once used a paper map and now use GPS. The tool changed, but the purpose stayed the same. That was the majority's basic idea. Second, the vote itself matters. This was not 5-4. It was 8:1. That means even several justices who often support strong gun rights agreed that this federal restriction could stand. When you see that kind of vote in a major constitutional case, it sends a message to lower courts. Slow down and stop treating every gun restriction like it's automatically doomed. But here's what nobody's talking about. The one dinner was Justice Clarence Thomas, the same justice who wrote Bruin. He said the government still had not shown enough historical support for this law. So the argument is not dead, not even close. One side is saying the court wisely adjusted course. The other side is saying the court bent its own rules when the facts got ugly. Here's where it gets interesting. The majority also rejected a broader argument from the government. The government wanted room to disarm people simply because they were not responsible. The court would not go that far. That word was too vague. So, the ruling helps the government in dangerousness cases, but it does not give officials unlimited power to label someone irresponsible and take away rights. Let me give you an example. Imagine a man in Texas is under a court order after a judge hears evidence that he threatened his partner and may do it again. He keeps a pistol in his truck anyway. Under current federal law, in many situations, that can lead to a serious criminal charge. And after this Supreme Court ruling, the Second Amendment protects me no matter what defense is much weaker. Now, imagine a different situation. A lawful gun owner gets into a messy breakup and someone tries to get a restraining order based on weak or false claims. Here's the part nobody talks about. Procedure matters. Due process, which means fair legal steps before the government acts, still matters a lot. Courts generally still need proper findings notice and a valid order before the gun restriction fully kicks in under the federal rule. Quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. If you're finding this helpful, imagine what you'll learn in my next video about red flag laws and emergency gun seizures. Subscribe so you don't miss it, because missing it could leave you depending on internet rumors when your rights are actually on the line. Third, here's what most people don't know about the bigger Second Amendment fight. Rahim did not erase Bruin. It changed how Bruin gets used. That's a huge difference. The court kept the history test, but it made clear that judges should look for principles, not museum-level copies of old statutes. That means lower courts now have more room to uphold modern laws if those laws are aimed at problems the country has always tried to handle, like threats, violence, and public safety. The court even warned against treating old history like the law is trapped in amber. That line matters because it tells judges they can apply old constitutional ideas to modern life without pretending America still runs on muskets and horse carts. Number 4. This does not mean every gun law now survives. Not even close. The court was careful. It focused on people found by a court to be a credible threat to someone else's physical safety. That is a narrower category than people the government doesn't trust or people officials think might cause trouble someday. So, if you hear someone say, the Supreme Court just approved all gun bans, that's not true. On the other hand, if you hear someone say this ruling means nothing, that's also wrong. This decision gives governments and lower courts stronger language to defend some firearm restrictions. Cases involving dangerous people, protective orders, public carry rules, serial numbers, age limits, and even some possession bans will now be argued through this updated lens. The battle didn't end. The map changed. Here's how this plays out in real life. A woman finally gets a protective order after months of threats, stalking, and one terrifying night in a parking lot. Before Rahim, some courts were entertaining arguments that the abuser still had a constitutional right to keep his guns. After Rahim, that woman has stronger legal backing for temporary protection while the order is active. That is not abstract. That is immediate. Now, let's talk about why the title says the Second Amendment fight took a massive turn. It's because the court just told everyone that historical tradition does not require a perfect match from the 1700s. That one idea changes how future gun cases are framed. Lawyers challenging gun laws now have a harder road when the government can point to an old principle instead of an exact old statute. Fifth, here's what most people don't know about timing. The ruling came in 2024, but as of 2026, courts are still sorting out the fallout. The Supreme Court has already been asked to weigh in on other gun disputes, including fights over who can carry on private property open to the public and whether unlawful drug users can be banned from having firearms. So, Rahim was not the ending. It was the setup. This is where it gets interesting for regular viewers who are not lawyers. You do not have to memorize case names to understand the shift. The old fear after Bruin was that almost every modern gun law could be attacked because America in 1791 did not have the same social problems, the same weapons, or the same legal systems we have now. Rahim pulled the court back from that cliff. Sixth, let me tell you what gun owners should take from this without panic. If you are law-abiding, not under a qualifying order, and not in one of the restricted categories under current law, Rahim did not suddenly erase your rights. But if you are under a domestic violence restraining order that meets federal requirements, or if you are close to that situation, pretending this ruling does not matter is a terrible mistake. Here's another example. Say a man hears from friends that federal gun law is collapsing and decides to keep his rifles after a judge has entered a protective order against him. He thinks a YouTube comment section gave him the truth. Then police find the weapons during another investigation. Now he is facing a federal charge, and the Supreme Court has already made the main constitutional argument much harder for him to win. Quick question. How many of you watching right now are actually subscribed? Only 15% are. Don't be in that 85%. Join the people who get these updates first. Click subscribe. Seventh, here's what most people don't know about rights and risk. Constitutional rights are real, but many rights have limits when there is a strong public safety reason and a lawful process behind it. Free speech has limits in certain settings. Property rights have limits. Even the Fourth Amendment, which guards against unreasonable searches, has exceptions. So, the fact that the Second Amendment has limits does not shock the court. But here's what nobody's talking about. The line between a real safety rule and government overreach is still the whole fight. Rahim does not answer every hard question. What counts as enough proof of dangerousness? How temporary is temporary? What about nonviolent felonies? What about marijuana users in states where marijuana is legal under state law, but not federal law? Those battles are still moving. Number 8. The 8:1 vote also tells us something political without being political. Even a court known for expanding gun rights is not willing to say the Second Amendment protects every armed person in every situation. That matters for lawmakers. It matters for prosecutors. And it matters for defense lawyers who now have to build arguments with more care instead of assuming Bruin alone will carry the day. Here's the part nobody talks about when these stories get turned into clickbait. A lot of people hear Second Amendment case and think the question is always whether guns win or gun control wins. That's too simple. Often the real question is who the law applies to, what process happened first, how long the restriction lasts, and whether the government can point to a genuine historical principle behind it. Let me tell you why that last part is so important. The Supreme Court is basically saying, show us the tradition, not a carbon copy. Tradition here means a pattern in American law showing that certain kinds of firearm rules were accepted. A carbon copy would mean the modern law must look almost identical to an old law. Rahim rejects that stricter view, and that is why this decision is such a big deal. Here's what most people don't know about how lower courts may use this. Judges who were nervous after Bruin now have cover to uphold at least some regulations. Expect more opinions saying things like this law targets danger or this law is similar in purpose and burden to earlier rules. That does not guarantee the government wins, but it gives the government a much better script than it had before. Now, let's be fair. Gun rights advocates still have arguments. They will say dangerousness can be stretched too far. They will say civil protective orders are not the same as criminal convictions. They will warn that once courts allow broad analogies to history, judges may start approving laws that go way beyond what the Constitution allows. Those concerns are not crazy. They are part of the real debate. At the same time, supporters of the ruling will say, common sense finally showed up. They will tell you the Constitution does not force the country to ignore real threats just because domestic violence laws in the founding era were weak or badly developed. And honestly, that argument landed with most of the court. That's why the vote was so lopsided. Look, I spend hours researching this so you don't have to. The least you can do is hit that subscribe button. These videos could help you understand your rights before you make a decision that costs you money, freedom, or both. Click it right now. So, what should you do with all of this today? First, stop getting legal advice from viral clips with dramatic music and zero nuance. Second, if you own firearms, know whether any court order applies to you right now. Third, if you are involved in a protective order case, whether you are seeking protection or defending against one, talk to a licensed attorney in your state immediately because details can change the outcome. If you're a victim or someone helping a victim, keep records, save messages, and understand what the order actually says. If you're the person subject to an order, don't guess, don't assume, and don't rely on what your buddy says the Constitution means. Read the order. Ask counsel. Follow the law while you challenge it if you plan to challenge it. That one step alone can keep a bad situation from becoming a federal case. Here's the main takeaway. The Supreme Court did not kill the Second Amendment, and it did not give the government a blank check. What it did do was make clear that courts can uphold some modern gun restrictions when those restrictions fit a real historical principle, especially when they target people a court has found to be dangerous. That is the massive turn. And here's what you need to do today. If this area touches your life in any way, learn the actual rule that applies to you, not the slogan. Check whether there is a court order, understand your state and federal exposure, and get real legal help before you act. In most jurisdictions, The biggest mistakes happen when people assume rights protect them in situations where the law has already carved out a serious exception. Subscribe now because the next video covers what red flag orders, carry bans on private property, and future Supreme Court gun cases could mean for ordinary people. And you need to see it before bad information makes a dangerous situation even worse. Stay safe. Stay informed. Sync to video time.